Welcome, and thank you for joining Seyfarth's webinar, How the California Privacy Rights Act Impacts Your Business in 2022. All participants are in listen-only mode. You're encouraged to submit questions throughout the program using the Q&A feature located on the right side of your WebEx window. We will do our best to get everyone's questions. However, if your question is not answered, our presenters will follow up with you directly in the days ahead. For those interested in CLE credit, an attendance verification code will be read during the presentation. Please write this code down. It will not be repeated and is required for CLE credit. Following the webinar, there will be a 15-minute office hours segment where attendees who stay connected can interact with our panel in an extended Q&A format. Copies of the webinar recording and materials will be distributed to attendees following the presentation. At this time, I'd like to turn the program over to John Tomaszewski. John, you may begin. You go.
Next slide, Christian. So thanks everybody for joining and taking time out of your busy day. We have an interesting panel of folks with a lot of deep experience in data protection law talking about how California's continued evolution in the privacy space is going to be impacting businesses and what that actually means, hopefully, for all of us in terms of understanding what we have to do next and what we don't have to do next. Next slide, please. I'm John Tomaszewski. I'm a partner in the Houston office and the co-chair of the Global Privacy and Cybersecurity practice here at Seyfarth Shaw. I've been practicing in this space for about 22 years, both as an in-house attorney, as a general counsel or a chief privacy officer, as well as with Seyfarth Shaw. I'm joined by Kathleen McConnell, who's a partner in our San Francisco office. She has a very wide background in data protection and privacy as well across the Americas, Europe, and Asia. She also works very heavily with clients in the e-discovery practice and has been doing an awful lot of very cutting edge work with us and our clients with regard to analytics. She does a lot of counseling around data analytics for discovery and litigation, and she's also published a number of pieces on data protection, cross-border privacy, e-discovery, analytics, and information governance topics. Also, I have with us Emily Dorner, who's an associate in the Chicago office. Emily is a member of both the e-discovery as well as the global privacy and security practice team. And she's done a number of work, projects around building actual compliance programs and working with clients to develop practical and applicable and efficient ways of dealing with very large amounts of data, both on the data protection side, as well as on the e-discovery and litigation side of things. So we've got a panel of folks that have three very different perspectives, but have done a lot of things in this space for a long time. Next slide, please. So really what we want to do today is we want to go over the current landscape because sometimes folks are seeing a lot of press and a lot of ink spilled in the trades around, okay, well, these are all of the things that California is going to require you to do. And this is all of the stuff that's going on and the sky is falling and it really isn't. So we're going to go over the current landscape and then we're going to go over what's changed because there have been some significant changes in the CCPA, and come January 1, 2023, we may have even more drastic changes depending on what happens with the legislature, but we'll get into that later. We'll also go over compliance and what compliance means and the kinds of things necessary to do compliance on both sides of whether or not the legislation changes this session or not. So with that, I'd like to turn it over to my illustrious panelists. Next slide, please.
Everybody. So I'm Kathleen McConnell, and I am situated here in our San Francisco office of Seyfarth Shaw. And to kind of kick this off, thank you for that introduction, John. We wanted to give you a little bit of the lay of the land for the current landscape to kind of set up what are the changes that we're anticipating with the CPRA, which are the potential changes, which are ones we think are likely to go into effect, just kind of give you some sense of where we're starting from currently. So as you probably recall, CCPA was passed in a bit of a panic. It was a response to a proposed ballot proposition by a privacy group known as the Californians for Consumer Privacy, which was mostly driven by a fellow named Alistair McTaggart. And in response to that the proposed proposition, the legislature, in exchange for taking that proposition off of the ballot, very quickly passed kind of a more scaled down version of the CCPA. That was signed into law in the summer of 2018 and slated to go into effect in January of 2020. There were some amendments to that in 2019, as long as a number of regulations that were issued around it that were revised a number of times. Kind of all testimony to the fact that this all came together very quickly with a lot of pressure. And perhaps one of the reasons that led to the passage of the CPRA not so much later. So that's just kind of a little bit of high level background. Next slide. All right. So, oh, I'm sorry. Can you go back one, Christian? Thank you. Okay, so kind of as a foundational proposition, we want to talk about is your business even covered by the CCPA to start with? And for that question, there are really kind of a handful of things that determine whether or not a business is covered. For one, you have to be a for-profit legal entity. You need to collect consumer personal information. You also need to both determine the purpose and the means of processing that personal information. You need to do business in California, seems probably pretty evident. And you also have to satisfy one or more of the following three characteristics. You either have to have gross revenues that are at or in excess of 25 million. Alone or in combination, you need to annually buy, receive, sell, or share for commercial purposes, either alone or in combination, the personal information of 50,000 or more consumers, households, or a bit of a tricky one, devices. The third prong is you can derive 50% or more of your annual revenue from selling consumers' personal information. So that's kind of like the threshold evaluation. Is your business even covered to start with? If the answer to that is yes, then we need to go on, look at some additional questions. Next slide, please, Christian. All right, so who is a consumer under the CCPA? A consumer is a natural person who's a California resident. And somewhat peculiarly, the statute defines a California resident as a person who qualifies under the tax code, basically. So you are a California resident for our purposes if you pay taxes essentially in California. So either you're a permanent resident of California and you might briefly be elsewhere, or you're somebody who is domiciled in the state for temporary or transitory purposes. Everybody else is a non-resident and is not a consumer. So basic takeaway, if you pay taxes in California, you qualify as a consumer. Next slide. All right, so assuming you're a covered business, you're dealing with consumer information. What is personal information under the CCPA? So personal information is defined really, really broadly. It is any information that relates to, describes, is capable of being associated with, could reasonably be linked directly or indirectly with a consumer, device, or household. The number of things that fall within this already broad definition is almost staggering. It includes anything that's an identifier, so things such as IP addresses, email addresses, account names, passport numbers fall under the identifiers. There's also this certain categories section, which refers to another section of the code, 1798.80, which gives another list of identifying information, which is again things like socials, signatures, employment information, education information, bank account numbers, really long list of things. Then you've got your kind of protected classification categories. You have commercial information that falls under personal information. You've probably not surprisingly biometric information, internet-related information. You have geolocation data, audio, electronic, visual, thermal, olfactory information. And then you have this whole category of inferences that are based on behavior. And this really gets at the information that is used to kind of create a profile about a consumer that reflects the consumer's preferences, their characteristics, their psychological trends, their predispositions. And this is something that we see come up most frequently in the targeted advertising context that we are all very familiar with in the social media world. Some of these things are going to move into the category of sensitive personal information, which we'll touch on more when we talk about the changes under the CPRA, but currently they all do fall under personal information. Importantly to note, there are some things that don't fall into personal information. That includes information that is quote unquote publicly available. Publicly available, it's not quite as broad of a term as you might think in common parlance. It doesn't mean like information that you can find on the web about somebody. It's really information that is lawfully made available from a federal, state, or local government record. So publicly available is really a pretty narrow range of things. It also doesn't mean any biometric information that might have been collected by a business without a consumer's knowledge. Another thing that it doesn't include is information that has been either aggregated or de-identified, anonymized, pseudonymized. That information is also excluded from the definition of personal information. All right, next slide, please. Okay, so now that we've kind of talked about businesses, consumers, what personal information means, another component of this is does something qualify as a sale for purposes of CCPA? And as with much of the other terminology in the CCPA, sale is defined, as you might not be surprised to hear, more broadly than you would think in common parlance. So again, here sale is really broad. It means selling, renting, releasing, disclosing, disseminating, making available, that's an important one to note, transferring or otherwise communicating consumers' personal information by the business to another business or to a third party. And another key kind of component of this is it doesn't necessarily need to be for monetary consideration. Monetary consideration certainly will bring the transfer into the context of a sale, but there can also be other valuable consideration exchanged. So just because you're not exchanging information for dollars does not mean that what you're doing doesn't constitute a sale under the CCPA. One thing to note is that, or I guess a couple things to note, it's not limited to online data collection, for one. And another exclusion is that transfers to a third party typically don't mean transfers to a service provider. All right, next slide, please. All right, so parties. We generally kind of from the business side have three groups of parties that are at issue, apart from the consumers themselves. So we have the business, which is the entity that has the direct relationship with the consumer. The business typically has the most obligations under the CCPA. The second kind of group of business side entities we see are service providers. Now, service providers, as the name might suggest, provide services to the business. The value chain is just between the business and the service provider. The service provider is not doing any other forwarding on of that data. They're not selling the consumer data. They're not doing anything else with it. They're just using it to support the business. And then we have the category of what's called third parties. Third parties are kind of interestingly defined because they're really kind of defined as what they're not. So for purposes of the CCPA, a third party is somebody who is not the business and who is not a service provider. They are an entity that is providing a service to the business, and they are usually either purchasing or receiving for their own commercial purposes personal information of consumers from the business. Next slide. All right. So talking about consumer privacy rights. Consumers have a lot of rights under the CCPA, even as it currently stands, without the revisions that we're looking at under the CPRA. So what they already have as it stands now is the right to know what personal information is being collected about them and to request deletion of that information. They have the right to know whether personal information is being sold or disclosed and to whom. They have the right to opt out of the sale of their PI. They also have the right to access that personal information. And they have the right to equal service and non-discrimination. They are entitled to not be discriminated against for exercising their rights under the CCPA, and they are entitled to not be retaliated against for that exercise as well. Next slide. So from the business side, there are kind of three general areas of obligations that we're seeing from the business side. The first kind of set of obligations that we're looking at is the duty to comply. And that includes a couple of components. We have the duty to comply in terms of posting notices of consumer rights. We need to inform the consumers of your data handling practices as part of that process. And we need to be able to respond to consumers exercising their rights under the CCPA. The second kind of prong of business side obligations is the duty to protect the security of personal information. One of the main driving reasons behind the passage of the CCPA in the first place was kind of narrowing and limiting the amount of data that might be at risk in case of a data breach, and also kind of limiting potential for identity theft and things along those lines. So protection and security of personal information is a fairly key component under the CCPA. Those requirements get even more stringent under the CPRA, which we'll touch on in more detail in a minute. And then finally, the last of the three groups of things that we see from the business side is there's a duty to both train employees to make sure that they're aware of the requirements under the CCPA and what the business needs to do in order to comply. And then there's also an obligation to make sure that your contracts are in keeping with the CCPA. So your business contracts, your service provider contracts, your third-party contracts all need to be compliant with the requirements of the CCPA.
And I'd like to add to that a little bit, the security and protection of the personal information. One of the things that's important to notice about that is there's a private right of action around that. And there's a private right of action associated with a statutory damages regime. As a consequence, unlike in other places outside of California that haven't enacted that, there's actual dollars associated with security breach, and you don't have standing or damages issues associated with that. So that's one of the reasons why that duty to protect personal information becomes so important. And by the way, that duty is there whether you're a business to consumer business or you're a business to business business. Because if you're processing information on a consumer, regardless of whether you're consumer facing or not, you're still going to be subject to the CCPA and CPRA.
Thank you, John. And I should have mentioned, John and Emily, please feel free to jump in. I know it makes it a little bit more dynamic if we've got a little bit more interaction going from the speaker side. So jump in at any time, and we'll help. Hopefully, I'll keep this dialogue a little bit more interactive, talking to the void of the internet. All right. So if you can move to the next slide, please. And actually, can we just jump to the next slide? I can go a little out of order here. So we wanted to talk a little bit about kind of the general rules of what is required from the business side in terms of providing notice and opportunities for contact around the request process from a consumer. So the general rule is that we want to provide notice of your business practices online. You want to make sure that that includes a consumer rights description and a method to submit the request. And it needs to include a list of the categories collected, sold, or disclosed. As part of that, we also need to provide methods for the consumers to submit their requests. One of those has to be a toll-free number. And the other one often is an online form submission and interactive form submission, but it can be one of a number of any other things, but one of them has to be the toll-free number. The third component here is you need to be able to receive verifiable requests and to confirm that the person making the request is actually the person that you think is making the request. Again, one of the tenets behind this is to kind of limit exposure of data to folks that shouldn't have it, identity theft, things along those lines. So there is a verification component. What you need to do in order to meet that verification component will depend on some degree to the sensitivity of the data involved. So if you've got, data that is low sensitivity, the verification requirements might be lower. If you've got something that's extremely sensitive, your verification requirements would be higher. There's not a lot of great guidance around this right now. Mostly it's to use like reasonably secure, reasonably justified methods in terms of verification. One of those that we see is, account protected, password protected accounts. However, you cannot force somebody to create an account or password protected account in order to submit a request. And then in terms of timeline, the business has 45 days to respond to a request. That can be extended to 90 if the business within the 45 responds to the requester and lets them know that the additional 45 is going to be required and provides a reason why they need the additional time. And if we could jump back to slide 13, please. Excellent. Okay, so let's say you've now gotten a privacy rights request. Do you have to turn over the information or otherwise comply with what the request is asking for? The answer is not always. More often than not, the requests are going to have a legitimate reason to not comply with them or to not fully comply with them. So you might be able to deny a request because you had consent. Consent's probably a little tricky because there's a very good argument that rights requests might be seen as a withdrawal of the consent by the requester. But more frequently, you might have a contractual obligation to keep the data. Much more frequently, you might have a legal obligation to keep the data. For instance, if you're, if you're a business, you need to keep wage records, you need to keep personnel files. There are other categories of documents that have to be retained due to legal considerations. And then another reason that you might be able to deny the request might be a legitimate business purpose. If you're only going to be able to grant a request in part, say it's a deletion request, some of the data that they're requesting to be deleted may be deleted, but the rest needs to be retained. You do need to be specific in your response in terms of the degree to which you are able to grant the request, and if you're to the degree you're not, substantiating that. So in terms of procedures to respond to rights requests, you need to acknowledge the requests come in. There needs to be a decision-making process to evaluate the request. There needs to be a response to the requester, and there should be documentation that support all of the parts of that. And something that's really important is to make sure that you're tracking this process so that you know that you're able to track a request when it comes in to when it's responded, and that those records are then kept, and to make sure that that tracking is done in a way that enables you to stay within the confines of the time requirements around the requests. All right, next slide. And one more. All right, and the last slide I'm going to cover here is extraterritorial application and the doing business component in California. So it's important to note that the Act requires for business entities, regardless of whether they're physically located in California. So if you are doing business in California or reaching into California to do business, even if you don't have a physical location here, you are going to fall within the confines of the CCPA as long as you meet the other threshold requirements that we discussed at the outset. And from there, I'm going to turn it over to Emily to talk about what's changing with the CPRA.
Thanks, Kathleen. And quickly, I'm going to announce the CLE code, which is SS as in Seyfarth Shaw 8390. One more time, SS 8390. Thanks so much. All right, we can go to the next slide and the one after. Okay, so Kathleen covered what's in the CCPA. What are we looking at right now? Before I dive into the differences, I'm going to point out what's not in the CCPA, and this will kind of inform the rest of our conversation here. So things that we'll see in these upcoming slides are completely new in this next iteration of the law. They include new laws surrounding sensitive personal information, new limitations to the collection of personal information, as well as the purposes for which information is collected. We also see new consumer rights and additional obligations on businesses as well. The CPRA also introduces kind of this first notion, at least in the United States, of data minimization. And these collection and purpose limitations are principles that just kind of further this larger data minimization initiative. Data minimization isn't something that's a foreign concept to those in Europe, but again, we're seeing it here in the United States for the first time. And essentially, at the most basic level, it requires that organizations limit the amount of personal information they collect, use, share, and store. In the most simple terms, the more data you have and the more data you control, the more likely you are to suffer a breach. And retaining consumer personal information for periods that are longer than those that are legally required goes against fundamental privacy principles of data protection, transparency, and data subject control over their personal information. John will speak a bit later to the importance and gravity of this change. Until then, let's dive into some more specific changes that will affect businesses. Next slide, please. The CCPA went into effect in June of 2018, and we expect that most people listening in today are either subject to the CCPA or think they might be subject to the CCPA or upcoming CPRA. There are some important changes to the scope of the application of the law that we'll address in a moment here, but before we get there, we'd like to first talk about the purpose of the enactment of these laws. So the California Constitution provides for an inalienable right to privacy. Looking at the history of that right, however, it was really meant to protect individuals from unnecessary government surveillance and governmental collection of records. So while individuals can technically sue under the California Constitution for violation of their privacy rights, we really don't see those claims very often. Instead, we see far more claims now under the CCPA. The main purpose of the CCPA, therefore, was to further the Constitution's inalienable right to privacy. So turning to the CPRA, this was passed by ballot just this past fall. It actually took effect in December of last year, but that was mainly for the purpose of establishing the CPPA, which we'll talk a little bit more about throughout the presentation, but they're essentially the new enforcer of this law. The vast majority of the provisions of the CPRA will become effective, however, on January 1st of 2023, which I'm sure is the date that's kind of ringing in most people's minds. So now the purpose of the CPRA is to further an individual's rights to control their own personal information and also to integrate fair information practice principles that weren't previously established in the CCPA. So these principles of data minimization initiatives and collection and use limitations. Next slide, please. So we've already touched on concepts that were missing from the CCPA. So what's new? What's new in the CPRA? Consumers have the right to rectification and correction of their personal information. They have new opt-out rights. The CPRA introduces a concept of sensitive personal information, and consumers actually have a right that goes along with that, which we'll get into in a bit more detail. And as discussed previously, the CPRA transitions rulemaking and enforcement to from the California Attorney General to the CPPA, which is the California Privacy Protection Agency. Next slide.
Now, one moment on that one. You still have to remember that the AG still does have residual enforcement authority. And so now you have two state agencies that can come after you instead of one. So the CPPA will be the primary enforcer, but we can't forget that the state AG still is going to have residual enforcement authority. And so you've got twice the number of resources that are going to be oriented on enforcing the CPRA than used to be.
Perfect. Thanks, John. And we can go to the next slide, Christian, please. Great. So we foreshadowed some changes to the scope of the CPRA. The CPRA, interestingly, both expands and narrows the definition of a business under the law. So as you can see here, we do keep that revenue threshold of $25 million. However, we're adding the concept of sharing personal information. It also increases the threshold of buying, selling, or sharing that personal information from 50,000 individuals to 100,000 individuals. It also changes that final threshold to deriving 50% or more of annual revenue from selling, or again, we're seeing sharing California consumer personal information. So we're seeing an expansion by adding that concept of sharing, but a narrowing by increasing the number of consumers that are affected in that second prong. So a little bit about sharing, why the need for the change here. And we'll talk about sharing a little bit more in a couple slides, but it's essentially the disclosure or exchange of personal information to a third party, again, and Kathleen mentioned this as well, whether for monetary gain or not. And this sounds really intimidating until we hear a large limitation on sharing itself that's a bit different from selling, and that is it has to be for the purpose of cross-contextual behavioral advertising. And this kind of shrinks things back down into a much more manageable and less intimidating box. We also see the CPRA making some changes related to how commonly controlled organizations qualify as a business, and more specifically, the concept of common branding. So what we mean in terms of that is under both CPRA and CCPA, the sharing of information from a business to a commonly controlled and commonly branded company brings that commonly branded company into the purview of the law. But the CPRA looks at common branding and also defines it as the use of trademarks or service marks in a manner that an average consumer would believe that the businesses are commonly owned. So this could really kind of expand what common branding means. And then in addition, they speak to joint ventures. So the CPRA states that joint ventures are partnerships that are composed of many businesses where each of those businesses hold at least a 40% interest in the joint venture, leads that joint venture to being considered a business under the CPRA. The final thing I want to mention on this slide is CPRA gives businesses the right to self-certify that they comply with CPRA, but what businesses need to understand is what comes along with that is agreeing to be bound by this law. So if it's something that businesses are considering, it should really be a decision that isn't handled lightly. Next slide, please. So we're going to talk about the changes to the categories of personal information. So the categories of personal information that the law covers have changed under the CPRA. Most importantly, the concept of sensitive personal information is introduced. The categories of sensitive personal information that are covered under the law are shown on the slide here. Under the CPRA, consumers can limit the use and disclosure of their sensitive personal information to certain business purposes. So this limitation of sensitive personal information comes into play when businesses want to use sensitive personal information for secondary purposes. So what are the permitted purposes? Permitted purposes of the use of sensitive personal information could be performing the services or providing the goods that are expected by the consumer. It could be protecting the consumer's information. It can also be non-personalized advertising. So this means advertising that doesn't include sending personal information to a third party or creating a profile about the consumer. Another permitted purpose can also be maintaining an account or providing customer service, kind of the day-to-day running of a business. And then finally, just maintaining the quality and enhancing the quality of the business. A quick note here is that we could also see a bit of an expansion here from the CPPA once we get our regulations. Unfortunately, we don't have those yet, and we'll talk to the timeline on when we expect those a bit later. It's also important to mention in this context that service providers and contractors working with the business are also going to be required to limit the use of sensitive personal information to these business purposes that they help perform for the business under the law. Next slide, please. So next we're going to talk about data subject rights, or consumer rights, which are also expanded under the CPRA. So in addition to the rights that were already present under CCPA, consumers now have the right to rectification and correction of their personal information. That said, it's really always in an organization's best interest to keep accurate and up-to-date information about their consumers and their employees for that matter. So while this is a new right, we expect most organizations are actually probably already compliant with this. In addition, we're seeing opt-out rights. for cross-contextual behavioral advertising and opt out for the use of automated decision-making. So with regards to behavioral advertising, this does create some new obligations for a business. Formerly, under the CCPA, businesses that sold personal information needed to have that little link at the bottom of their homepage that said, "Do not sell my personal information." Now, this link under CPRA is probably going to need to be changed a little bit to reflect the concept of sharing. So it's going to say, "Do not sell or share my personal information." But another thing that organizations can do is rely on browser opt-out preference signals that are sent with the consumer's consent. So under CPRA, an opt-out signal is seen as a valid request by the consumer to opt out of the sale or sharing of their personal information. There is an exception here, and that's when the consumer provides consent or opts into behavioral advertising. So more specifically, the CPRA says that if a consumer uses or directs a business to intentionally disclose personal information or interact with one or more third parties, then those disclosures do not constitute sharing under CPRA. Since those disclosures don't constitute sharing under CPRA, then the CPRA's requirement to provide an opt-out mechanism also doesn't apply. So these businesses don't need to post that "do not sell or share my personal information" link, and they don't have to listen to those opt-out signals. So similarly, with regards to automated decision-making, consumers also have the right to opt out of this. And this comes into play when businesses create or hire another company to create a profile about consumers to predict their interests, their behavior, their personal preferences, and things like that. I'm sure everyone's seen targeted ads on social media. We expect to see more regulations here too, especially with regards to access and opt-out rights and businesses' use of automated decision-making. Again, we'll have to wait for the regs to see those. And then finally, with regards to limitation in use and disclosure of sensitive personal information. We've talked about sensitive personal information, but we haven't necessarily talked about what businesses have to do in response to consumers exercising this right to limit. And it looks a lot like the other opt-out mechanisms. So businesses essentially need a link on their homepage that says, "Limit the use of my sensitive personal information." They can also have kind of a combined link that allows the consumer to opt out of selling and sharing, as well as limiting the use of their sensitive personal information. They're also allowed to respect those opt-out preference signals in the same way with regards to sensitive personal information. Next slide, please.
And the opt-outs are going to be particularly annoying because the way personal information is defined really broadly includes things like cookie identifiers and global generic identifiers, and all of those things that are identifiers for the behavioral advertising companies, but not necessarily identifiers for the property owner for the website. And so having this obligation to opt out of cross-contextual behavioral advertising can be really challenging, because the identifier that you're looking at, you may not know who that applies to. And this is where life gets really, really complicated in Europe, because this has been that way in Europe for a while, but this is new in the United States. And so it's going to be somewhat challenging because of the breadth of the definition to include things like cookie identifiers on a particular browser. That's actually relatable to a discrete individual. So it's going to be an interesting challenge, both technologically as well as from a policy and procedure perspective.
Okay, Christian, we can go to the next slide. Perfect. Okay, so we spoke a little bit about data minimization and certain limitations that fall within this broader scope of general privacy principles. These limitations are, again, nothing new to those subject to the GDPR, but it's a wholly new concept in the United States, and it presents a significant change. Under CCPA, the purposes for collection of personal information were to be disclosed to a consumer or an employee in a notice. Interestingly, the California Attorney General actually did try to limit this in its regulations to require consent for a secondary use or a materially different use from the original purpose for collection. However, this was ultimately struck. Here under the CPRA, we're seeing a codification of this purpose limitation requirement, as well as data minimization and storage limitations. So what does this mean? The business should be prepared to disclose all purposes for which personal information is collected and to ensure that it's using data only for those purposes. So if there's a new purpose, it has to be disclosed in the consumer notice. Businesses should also collect information from a consumer that's necessary and proportionate to the purposes for collection. So it shouldn't be collecting anything more than it needs to accomplish a certain goal. And then finally, businesses need to comply with storage limitation principles. So this includes deleting data when the purpose for collection is over. And it's also consistent with the need for an enterprise records retention program, which lays out the records an organization maintains and the legally required periods for which that data is maintained. Next slide, please. All right, children's data. So under the CPRA, we do see a similar requirement for how children's data is to be addressed. So essentially, if a consumer is under the age of 16, has declined consent to sell or share their personal information, a business has to either wait a year or wait until that consumer is over the age of 16 to ask for their opt-in consent again. Something important to call out here is that willful disregard of a consumer's age is seen as actual knowledge of a consumer's age. This is something that requires a lot of attention, especially in light of CPRA's changes. So what's different under CPRA is how these violations are punished. CPRA has tripled the fines for collection and selling of children's personal information up to $7,500 per violation when a business has actual knowledge that the consumer is under the age of 16. So again, actual knowledge can equal willful disregard of the consumer's knowledge. So what this tells us is that the enforcement in this area is going to be strong and it's going to be consequential. Next slide, please. So the CPRA also attempts to make some distinctions and some differences. And in a lot of circumstances, we think that the bark is actually a lot bigger than the bite. So we're going to break down a couple of these for you. So let's take, for example, the differentiation between a service provider, a third party, and a contractor. We've talked about service providers, we've talked a little bit about contractors and third parties, but more specifically, service providers are a person that processes personal information on behalf of a business that receives from or on behalf of a business consumers' personal information for a business purpose pursuant to a written contract. So this could be like a payroll processor. A contractor, on the other hand, is defined as a person to whom the business makes available a consumer's personal information for a business purpose and pursuant to a written contract. And then finally, a third party is defined essentially to what Kathleen was talking about by what it's not. So a third party is a person other than a business, a service provider, or a contractor. Think of a third party as maybe your third party ad agency. So it's not really immediately clear why service providers and contractors are differentiated under CPRA, given that the requirements that it places on each are almost entirely the same. The only real difference we see here is that contractors aren't processors of data, and they have to certify compliance with contractual provisions. With both contractors and service providers, there's no notion of a sale. That really only comes into play with third parties. So all in all, this distinction between service providers and contractors really isn't a big one. It's not something to worry too much about, so long as the business is ensuring that contractual terms governing these relationships are ensuring that personal information is only retained and used for business purposes, personal information isn't sold, and personal information is only retained within the scope of the business relationship. In addition to those, the only real thing that a contractor would have to do is certify their understanding of and compliance with those terms. So it's really not a huge leap. We also see a distinction between selling versus sharing of personal information and how those two concepts are treated under the CCPA. So they're treated the same under the CCPA, excuse me. Selling is the disclosure of a consumer's personal information to a third party for monetary or other valuable consideration. This really doesn't change much under CPRA, But with CPRA, we get this new term of sharing. It has a very narrow definition, as we discussed. It is just the disclosure of personal information to a third party, again, with this big limiter for cross-context behavioral advertising. So whether or not there's monetary or other valuable consideration. And what's more is that selling and sharing are regulated in the same way. So consumers have a right to opt out of the sale or sharing of their personal information, and businesses, on the other hand, have the same duty to disclose their practices with regards to selling or sharing. So the change actually really drives at providing some additional clarity regarding this other valuable consideration portion that the term selling makes. And it makes completely sure that consumers have the right to ensure that absent any type of monetary exchange for their information, that they have control over their personal data and they can opt out of these advertising mechanisms. Coincidentally, it also gives businesses a bit of a softer term to work with when presenting their opt-out links on home pages. Many businesses prefer the optics of how do not sell or share my personal information sounds, as opposed to a little bit more blunt, do not sell my personal information, which can very easily be misinterpreted and sound a bit alarming to an average consumer. Next slide, please. Now, something completely new with the CPRA is the additional business requirements to conduct annual cybersecurity audits and annual risk assessments if the processing of a consumer's personal information presents a significant risk to a consumer's privacy or security. This probably, again, sounds really familiar to those that are subject to GDPR. Right now, what we know about this is that audits and risk assessments will be required, and that businesses will need to define an audit scope, ensure that they're thorough, and ensure that they're independent. Risk assessments will need to be submitted to the CPPA and disclose whether processing includes sensitive personal information. If it does include sensitive personal information, they also need to identify and weigh the benefits and the potential risks of the processing. So this is really all we know on this for now. We'll again need to weigh on regulations for a little bit more detail on what will be involved, but in the interim, we think a really good place to turn to look for what to expect would be the GDPR. And next slide, please. It's a really nice segue actually into enforcement and fines. So as we've discussed, the CPRA will be enforced by the CPPA, unlike the CCPA, which is currently enforced by the California Attorney General. So along with enforcement comes obligations for rulemaking. So when can we expect these rules? They were originally due on July 1st of 2022. However, we've recently learned that this will unfortunately not be the case. It will put some additional pressure on businesses to comply and to comply quickly. The CPPA recently announced that their rulemaking will begin in Q2, so hopefully in just a couple of days. Those public hearings and formal proceedings will then go through Q3 of this year. Very possible, as a result, that we won't see any regulations until the Q4 of this year. While this sounds really frustrating, recall that the CCPA regulations went through various iterations following their release. So it's possible that this kind of slow and steady measure twice, cut once approach could actually be beneficial for us in the long run. Also, while not in its most recent announcement, the CPPA did foreshadow at the end of last year the possibility of them not making this rulemaking deadline, and also mentioned the potential for extensions or the enactment of temporary or emergency regulations or some compliance grace periods. Again, they didn't mention that in their latest release, so as Q4 grows near, we'll just have to hope that that happens for us. In the meantime, businesses should really just position themselves as best as possible to comply with what we know now based on the rules of the CPRA. We've already covered fines a bit under CPRA, and at this point, I think I'm going to turn things over to John to discuss compliance. What I expect is a burning question for a lot of you, which is the employee exemption, and more on what businesses can be doing in 2022 to prepare. Thank you.
Thanks, Emily. Next slide, please. there's a lot of stuff that's really scary in the CCPA and CPRA around what we have to do, but there are also a nice long laundry list of exemptions. Most of this is associated with trying to make sure that the CCPA doesn't get overturned for violating the Dormant Commerce Clause, like certain other California laws have happened. So there are specific carve-outs for covered entities under HIPAA and business associates, for example. Any activity governed by the FCRA and any data governed by Gramm-Leach-Bliley, which is the financial privacy regulations. There are a number of other laws that are included in there, like, for example, the Driver Privacy Protection Act and the Video Privacy Protection Act. But basically what we're trying to do with these exemptions is we're trying to make these exemptions implemented to ensure that the entire law doesn't get attacked under constitutional grounds. That's the reason why that's there, which is great. It's something that we've seen California do in the past, and they had to actually amend it a couple of times to make sure those exemptions work properly. The two components that I think right now are most important for a lot of folks on the call are, do you have to do all of this, all of these options and all of these analyses and all of these risk assessments and all of these consents and everything else with your employees? And the short answer is not right now. Do you have to do that with your business's employees? There was a question earlier around, does the CCPA apply to B2B businesses? They apply to B2B businesses where your client is giving you consumer data about them to process. They don't apply in a B2B context where the only personal data you're processing is that of your employees and your client's employees, or your vendor's employees for that matter. This is really important because it basically means the only obligation you have to your employees under the CCPA right now is to give them a very basic notice of what data you're collecting and what you're using it for. In the event that that goes away in January 2023, the rest of the CCPA is going, and CCPRA is going to then apply to your employees and your vendors and clients' employees. Next slide. Very much like what happened with the definition of consumer in the first place, the last legislative session before the CCPA was about to go into effect, the legislature amended the definition. They didn't amend the definition. They amended the exemptions to basically say the CCPA doesn't apply to employees. It was a 11th hour amendment. It's something that a lot of folks were very, very happy to see that happen. But there was a sunset provision that was put in place. Then when the CPRA got passed, it actually pushed out that sunset provision by 1 year. Had the CPRA not been passed, employees would already be subject to the CCPA because as of 2021, under the old law, it would have expired. Now we have the CPRA that pushes it out another year. And now what we have is we have two bills in the State House that are basically saying, look, we recognize that it doesn't make a lot of sense, practically speaking, to impose all of the traditional consumer protections onto an employee. If the employees need to have protections, that shows up in the labor code, not necessarily in the civil code. So what we're going to see is we're going to see these bills, 2891 and 2871, attempt to extend the exemptions of employees and business relationships. So the employees of your vendors, the owners of your vendors, the employees of your clients, et cetera. One of them is looking at extending it out 3 years. The other one is looking at extending it out permanently. The bottom line on this is a very good idea in terms of being able to impose a level of consistency on businesses, because that way you don't have competing obligations between the labor code and the civil code associated with this. Regardless of what your opinion is in terms of privacy, having consistency in the code is always a good thing. So the smart money right now is that this is going to happen, and we're closely watching the committee meetings on these two bills to see whether or not the votes look like these bills have legs. If they don't, then after August 31st of 2022, we're going to have a very, very short time frame to take all of those obligations and all of those requirements under the CCPA, plus the new requirements under the CPRA, and apply those to your employees and apply those to your clients' employees. So this is going to be an interesting legislative exercise. And if you want to spend money on CPRA compliance right now, my recommendation is spend it on a lobbyist. Next slide. We've already kind of talked about this. The thing that I want to really point to that is going to be the new and unique problem that a lot of employers are going to have is, remember that collection and purpose limitation that we talked about previously? This is really going to have, if it does end up applying to employers, this is going to have a significant challenge, because for the most part, businesses collect all information about employees. Any information associated with how the employee is operating as an employee is collected by the employer. If the CPRA comes into effect and has that collection and purpose limitation imposed on it, that broad right of collection and use ends up getting limited in a very significant, very material way. And the employer is going to have to demonstrate what the purpose is and why the data is necessary for that purpose if the CPRA comes into effect. This is a significant administrative tax on businesses and a significant compliance burden on HR departments and IT departments, because it used to be, well, you're an employee, and so I collect all the information about you as you're operating as an employee. That's going to end up having to go away. So it's going to be a real challenge in the event that the employee exemption expires, because not only are you going to see all of those bulleted things that are going to be applicable to employees now you're going to also start to see things like purpose and collection limitation and no secondary use imposed on employee data. Next slide. So, planning for the coming year. First thing is, let's plan on making sure the employee exemption actually occurs. Quick thing to note, the employee exemption does not cover the obligation to implement reasonable security to protect employee data. That's been in the CCPA, that's in the CPRA, that has never been contemplated in terms of being taken off the table. So understand you have information security obligations around employee data the same way you do around consumer data. That's different than all those other privacy obligations that we saw. The other thing that's going to be important now is to also take a look at beneficiary data, because that's sometimes where you'll see children's data for your employees. And so I think it's a good idea, not only from the perspective of compliance, but also from the perspective of understanding whether you do or do not have to comply in terms of building a data inventory. What data do you have? What are you using it for? But at a higher level, not necessarily the same detailed level that the risk assessment would require in the event that employee data was subject to the CPRA. The other thing I think that's really important is look at your records retention schedule, look at your records retention program, understand that if you have a records retention program, it's just as important to have a records deletion part of that records retention program. Don't stop at saying we can hold on to this data for 7 years. A lot of our clients say, well, we can hold on to this data for 7 years, and then they never delete anything at all ever. You know, if you don't need it anymore, truly don't need it anymore, look at implementing a legitimate records deletion component to your records retention process. One, that's good information governance. And two, in the event that the employee exemption goes away, you'll already have done a serious amount of the heavy lift associated with these new obligations around collection limitation, purpose limitation, and storage limitation. I think the other thing that's important to look at in terms of records retention is understanding that there are various purposes for retaining the record. Those are going to come out of statutes of limitation. And that's really where you go to look for how long you retain your record. Sometimes you're going to have the same data in different record types. And so that's something that we spend a lot of time dealing with our clients around, but that's going to be part of a larger records retention program that you really need to customize for your own business. And then obviously there are a number of processes and procedures. Interestingly enough, some of these you may already have. For example, data portability is something that could be translated into access to employment records, or rectification and correction is something that you see with online accounts very easily. It's like, hey, I want to go in and change my address. Easy enough to do. Where I think life is going to get interesting is thinking about opt-outs and what truly is cross-contextual advertising. Basically, if your website participates in an affiliate ad network, you're sharing or selling personal information. So looking at your your website infrastructure is going to be important as well. And then finally, that sensitive personal information component, we have to be careful about, because certain aspects of sensitive personal information are defined as protected under California law. That same information may be required to be disclosed or used under equal employment law. So there's going to be some balancing that goes on in terms of how sensitive personal information under certain categories can be managed. And then finally, and this is really critical path, vendor and client management of the contracts, making sure that you've got a vendor management program, making sure that you got the right language in your agreements with your vendors and with your clients associated with this, because even if they're not going to be subject to the CPRA, this is one of your primary risk points associated with doing business in the information age, because data is the new asset. And with that, I will turn it over to some questions, since we're a minute over.
We do have some questions in the Q&A. We had a couple of questions about what the acronym OBA stands for, and that's shorthand for online behavioral advertising, which is really the that targeted advertising that we see in the social media context that we were discussing earlier. That is the OBA reference.